Vincent versus Ottawa City, 2007. Section 25 of that judgment states that Courts of Justice Act reads as follows. The Superior Court of Justice has all the jurisdiction, power, and authority historically exercised by courts of common law and equity. The Supreme Court of Canada has made it clear in cases such as M.A. versus Ryan, which was a case in 1997, that the common law in Canada must develop in accordance with charter values. A trespass in common law equals an infringement or denial of a fundamental right or freedom. Another judgment here in Canada, Mitchie Estate versus City of Toronto. At page 268-9, you see that it says, it appears clear that the Supreme Court has broad universal jurisdiction over all matters of substantive law. The rule of law relating to the jurisdiction of superior courts was laid down at least as early as 1667 in the case of Peacock versus Bell and Kendale. And the rule for jurisdiction is that nothing shall be intended to be out of the jurisdiction of a superior court, but that which specifically appears to be so. Scarola versus the Minister of National Revenue, 2002. In Article 27, where the judgment is, he was quoting another judgment in R versus unnamed person. It says the term inherent jurisdiction is one that is commonly and not always accurately used when arguments are made with respect to the jurisdictional basis upon which a court is asked to make a particular order. The inherent jurisdiction of superior court is derived not from any statute or rule of law, but from the very nature of the court as a superior court. In Scarola versus Minister of National Revenue, 2002, Article 25, it states, again he's talking about another judgment, in Bougie versus the Queen. It says the court, meaning the superior court, as a statutory creation, does not have inherent jurisdiction. Okay, so I want to be looking into the court structure, how the court operates, and what's actually transpiring when you go to court. Now, what matters to me is that there's two sides of the court, two types of courts that are in operation. Now, on one hand, the court is considered a statutory creation. This is a court that is controlled or is in operation through enactments and regulations. That's considered a statutory court. Now, on the other hand of a court, there's something that's called the inherent jurisdiction. That's the terminology of it. Inherent jurisdiction. And it doesn't come from enactments or regulations, this power, the inherent jurisdiction, but from the very nature of the court. So, two sides of a court. On one hand, it's a statutory creation where it is controlled by regulations and enactments. On the other side of the court, it has inherent jurisdiction and it's not controlled by regulations or enactments. Now, an example of a statutory court would be, for example, a traffic court. So you know when you get a traffic ticket, when you're out there driving in the motor vehicle and they issue you a ticket, they're asking you to come forward and come present your case in a statutory court. The judge that is sitting there, he is being controlled by the enactment and regulations. He is being controlled by an enactment that's been created to control that specific traffic court. So the court, as a statutory creation, it doesn't have the inherent jurisdiction, doesn't have all power to deal with all situations. But the court, as an inherent jurisdiction, its power is not from statute or rule of law. Its power comes from the very nature of the court. Now, in the inherent jurisdiction of the court, nothing is outside of its power. That represents the inherent jurisdiction. Nothing's outside of its power. And if a right exists, that alone creates power or jurisdiction to place within the inherent jurisdiction. So let's look at it like this. You got a superior court, Supreme Court or Superior Court. Now, this court has inherent jurisdiction. It has that power and can operate that power. Now, if there's a right that exists in Canada, in America, in Russia, whatever country you are in, if you have a right that exists, then that alone creates the jurisdiction through the inherent power, inherent jurisdiction, to give it to the court. In Board versus Board, this is an older judgment. It shows us the nature of the court and the inherent jurisdiction of the court. It says that the Privy Council, in dealing with the question of the nature of the jurisdiction of a superior court, said, if the right exists, the presumption is that there is a court which can enforce it. For, if no other mode of enforcing is prescribed, that alone is sufficient to give jurisdiction to the King's Court of Justice. Nowadays, that would be the Queen's Court of Justice. In order to oust jurisdiction, it is necessary, in the absence of a special law, excluding it altogether, to plead that jurisdiction exists in some other court. Looking into the international covenants on civil and political rights, or economic, social, and cultural rights, we understand that we all have natural rights and fundamental freedoms that are now recognized and guaranteed through our constitutions. So our rights exist. And if our rights exist, then that is sufficient to give jurisdiction, to give power to the superior courts, supreme courts. Now, this inherent jurisdiction that it operates, it can enforce the right. It can produce the remedy. That's how this is working out. So if the right exists, then the inherent jurisdiction of a court can enforce the right. It can enforce the right because it's an obligation. What they don't want you to do is present yourself properly before the court and express what's going on and access the inherent jurisdiction of the court to seek the administration of justice concerning your natural fundamental rights and freedoms. Because when you go to court, they want you to go in there and stand under statutory and regulations. They want you to stand as a court that's a statutory creation. Why? Because then it doesn't have inherent jurisdiction, the court. If you go in there screaming and yelling that your fundamental rights and freedoms have been removed from you, that the state party, the executive party, the legislative party have removed or are abridging or limiting your fundamental rights and freedoms, the court says, I'm sorry, I can't hear you. I'm a statutory creation. I don't hear this type of pleading. I don't hear this type of cause. But if you go in there and you access the side of the court that it has the inherent jurisdiction, and if you prove to the court that a right exists, then the court has to take jurisdiction over that right, and it must enforce or produce the remedy on your behalf. Again, court, as a statutory creation, is controlled by enactments. It doesn't have the inherent power that we're looking for when we seek the administration of justice. We walk into that type of court, we can't access the power that we're looking for. The court, as inherent jurisdiction, as a superior or supreme court, it operates before the dominion was in existence. The power that's operating in inherent jurisdiction under common law, which we now know is enforced through our charter rights, thanks to R versus Haynes. It tells us now that a breach of our common law must flow out of the charter rights, must flow out of the international covenants, but it operates, this power, inherent jurisdiction, operates before the dominion was in existence, and it clearly says that if there's a right that is in existence in our territory, that this grants this court, the jurisdiction to hear the right, and therefore it can produce a remedy, and it can enforce fundamental rights and freedoms. Now again, I'm going to stick to Canadian references here. When you go into court from the statutory side, the Crown, which is usually who you go against if they're calling you into court, or if you decide to take them to court to challenge them, the Crown wants to keep it in a statutory created court. They don't want you to be able to access this side of the court. Why? Because on that side of the court, the inherent jurisdiction, you grant the judge the right and the power to enforce and produce a remedy on your behalf. If the Crown can trick you with or without the help of the judge, not judging, but I've seen a lot of bad things going on here in our country, particularly. If the Crown, with or without the help of the judge, can get you to stay under an enactment or under a regulation, then you can't access the inherent power of the court, and you can't seek the administration of justice. You can't go in there and say, well, listen, I have a right in the Constitution, or I have a right in international law, and this enactment that the executive powers and legislators of my country have created has removed my right. It's stripping me of my right. He's going to say, I can't hear that. What are you talking about? That's why it's so important when you go to court that you present yourself properly before the court to get out of the statutory creation and get into the inherent jurisdiction. Now, how does that transpire? Well, hopefully long before you ever go to court, you've notified the state party of your territory, whether it be America, Canada, Russia, United Kingdom, Great Britain, Australia, many of the other countries that are signatories to these covenants. You got to notify the executive powers and state to them, listen, I know you've abridged my rights, I know you've limited some of my rights and freedoms, and I'm just letting you know that you haven't fulfilled your obligations. That's what I talk about under a claim of recognition. A claim to recognition of your rights. I have rights and you're stripping me them through your domestic law. That's the first step. Because before you ever get into court, the Crown can say, hey, well, listen, you had rights and you were exercising the rights, and since you never said anything to us, we just assumed that it was okay. For example, no one can be held in servitude. Yet in Canada, we're under an oath of allegiance. We pledge allegiance to Her Majesty the Queen, and we promise to obey the laws of Canada. We're being held under servitude in that way. And they're saying, well, you automatically accepted it. Why? Because you tacitly agreed. You never said otherwise. So now I run to court and I complain to the judge, hey judge, the Crown has made a violation against me. Her Majesty has made a violation against me. And the Crown comes back and says, what do you mean? You never said anything. What do you mean? So that claim of recognition, your first communication with them saying, hey, I have fundamental rights and freedoms that you're not respecting. I found out you have an obligation towards me through international law, through the Constitution Act, and I'm just letting you know that I've caught you limiting and abridging my rights. Therefore, now the Crown's been put on notice. So when you're in court seeking the inherent jurisdiction, there's no excuse. The Crown is standing there. They can't say, well, we were under the impression that he tacitly agreed. No, he notified you and he told you straight up. Some of the actions that your state party is taking is limiting and abridging my fundamental rights and freedoms. You're not supposed to do that. All this was put into existence. The international covenants, human rights, and all this was put into existence to protect us as individuals, as men and women, against such atrocities that happen, such as World War II. And now here, through your own domestic laws, you're just ransacking all these obligations. You could care less about your obligations, and you're seeking to limit my rights and freedoms. You're a little Hitler in the shadows. That's what you're doing. So when you go to court, you've told them, through your claim of recognition, that they've limited and abridged some of your fundamental rights and freedoms. Now when you walk in there, the judge is going to say, Mr. Such and Such. Let's use John Smith, for example. Mr. John Smith, please approach the bench. Now the problem right there is by he's calling you Mr. Were you born a Mr.? No, right? Now what happened right there is they put a title upon you. Some will say, oh, it's just courteous. That's what they're doing to you. Absolutely not. Remember, I've taught you in my videos, and I've showed you in my video, what they want to do is remove your original designation. So if we're born men and women, human beings, without any other titles, without any further designations. After that, we become students, employers, you understand? Workers, drivers, all these titles that they put on us to take away our designation of man or woman. Because when we stand under these other designations, we're not standing under our natural recognition, under our natural rights, our fundamental rights and freedoms. If you're a worker, you're classified as a worker. If you're a nurse, you're classified as a nurse. If you're a mayor, you're classified as a mayor. And all these positions are controlled. For example, if I'm a student, right? If I go to school, you see, the designation student, I'm controlled by what I can do. I got to show up on a certain time. I got to go to recess. I got to go to lunch. What I'm trying to show you is that every designation is controlled. And they change you. They get you out of your natural recognition of man or woman and classify you under some type of legal designation, some type of legal title. Now they call you Mr. John Smith. And what they're doing right there is they're trying to put the court into a statutory court. into a statutory creation. That's what they're doing by stating this. Now you contradict that by presenting your live birth, your live registration of birth, and saying this is who I am. End of story. Why? Because we learned through the Vital Statistics Act across Canada, and it's the same in all our countries, but we learned that that's the only documentation that we can get our hands on that actually recognizes and brings forth the fact that we are living human beings, men and women. And as living human beings, we have fundamental rights and freedoms that we can exercise. And further to that, within the enactment, it states that this document, our live registration of birth, cannot be contested. It's prima facie evidence. So when we present it to the judge, he's under obligation, according to the enactment, according to the duty that rests upon him, to recognize the fact that now standing before me is indeed no longer Mr. John Smith, but John Smith himself. And John Smith has all his fundamental rights and freedoms. And John Smith now is accessing the inherent jurisdiction of the court. That's what's going on. So you have to get that out of the way. Now, once that has transpired and you have the inherent jurisdiction of the court, what's the next step? When you understand the step process to enforcing your fundamental rights and freedoms, long before you ever get to that court, you're going to have notified the Attorney General, whether it's the Federal Attorney General or the Provincial Attorney General, depending on what right you are saying has been limited or abridged. They're going to know. They have to be notified. So the court is aware, and they are aware that you are coming to this court now presently to seek the administration of justice, which means you are seeking the inherent jurisdiction of the court. All this is going to be, let's see, if you'll say, pre-arranged by you notifying the Attorney General. Now the problem is that if you show up there and they start playing games, at this point, you need to put a stop to it. If they're calling you Mr. or trying to operate the court under statutory power and not under its inherent jurisdiction, you have to stop them directly there and make sure that they're recognizing you through your live registration of birth, through your claim of recognition, and not as that legal entity which is a creation of society given rights and duties within this context of its operation. That's very important. Now, if the judge leaves, some people say, well, the judge is going to get up, leave the court, and come back and changes the face of the court. Yes and no. It doesn't really matter. If the judge calls a recess and leaves and comes back, you can go through it again. Okay, judge, for and on the record, here I am. I'm stating my status. That's what you want to say. I'm stating my recognition for and on the record. I'm testifying to it. You want to actually get up there and testify to it on the record that according to your live registration of birth, that the one who's standing before the court right now is a man or a woman with all their fundamental rights and freedoms and not willing to give any of them up. Once that's all established, and it's important to keep that established, now the onus is on you to prove that there's been a limitation or an abridgment of your rights and your fundamental freedoms. You would have to do that to prove the violation. You have to go through international law. You'd have to prove that your state party has an obligation to these international laws and that they failed to respect them. You'd have to walk the court through international law, through flowing down into the Constitution Act of your country. So remember, in Canada, we know it's the 1982 Constitution. In Russia, it's the Constitution of the Federation that was made in 1993. In America, it's the Constitution Act, but it's something called the Supremacy Clause, which brings in the international covenants. We have to prove that we have these rights. Our natural fundamental rights and freedoms are common law rights. Common law rights. Then we'd have to go further and prove which enactment or which action, because remember, when we're learning about all this, it's not only enactments that are of no force or effect against us, it's actually the actions that these agents take. So the courts could say, well, no, the enactment doesn't violate. The enactment itself, it doesn't violate any principles. But yet, based upon the enactment, these agents take actions. And these actions actually violate our fundamental rights and freedoms. The courts have made a double distinction there. So we have to prove that the enactment breached our fundamental right and freedom, or the actions of the agents breached our fundamental right and freedom. And then a remedy would be produced. Why? Because the court has inherent jurisdiction and it must produce the remedy. It's under obligation. And if the court continues to play games under its inherent jurisdiction and not produce these remedies, then Canada, America, Russia are opening themselves up to international scrutiny if some of us decide to go there and start making some complaints against them, because the judiciary here or there is refusing to do their duty and refusing to respect and produce remedies on our behalf. So that's the operation of the court system that we have going on. We want to make sure that we access the inherent jurisdiction to make sure we get the administration of justice. To make sure we get that administration of justice. Because if we don't, again, they're going to shut us down completely by putting us into a statutory court. And if you don't know what's going on and if you don't know what you're doing, then you're going to walk away beaten up even more. They're going to charge you extra fees and they're going to damage you. So it's important to know this. I get to court, what's going on? There's two courts that can operate. That's it. People talk about this court and that court. There's two courts in operation. One that's called a statutory court, statutory creation, such as a traffic court, such as a fishing court when you don't have a fishing license. It's administrative that they're doing there. And then you have the inherent jurisdiction of the court. And within the inherent jurisdiction of the court, anything can be enforced. If there's a right that is recognized, if there's a common law right, a fundamental right and freedom that is recognized, then it can be enforced through the inherent jurisdiction of that court. And the court must enforce it if we access it. But again, the onus is on us. We can't just go in there and say, oh, I'm a man or a woman, I have natural rights, and the state parties don't want to recognize my rights. That doesn't put any obligation upon the judge. Nothing at all. You have to go in there, present yourself, state who you are, and then walk them through. What do you mean you have fundamental rights and freedoms? Again, it starts international law. After Hitler did all that crazy stuff, men came together and realized, listen, we all have natural fundamental rights and freedoms that we were born with, and governments seem to want to take them away from us. And when the government starts taking away these rights and freedoms, they become way too powerful. So let's draw up a documentation that preserves these rights and freedoms for an individual, that if ever down the future the governments of this world start to rise up and begin to encroach upon these rights and freedoms, an individual will have the power to stand up and say, no, what are you doing? You don't have the right to do that to me. We've got to start walking them through international law, show the rights and freedoms that we have through the Constitution, show where the enactment or the action of the agent breached our right, and then say the remedy must be produced on our behalf. That's what we're doing. Go into court, make the distinction. Long before we arrive into court, we've already notified the attorney generals. We've already put a claim of recognition to tell them our rights have been limited or abridged. We came to court on that day. We presented a live registration of birth, but however, the court was already notified. But just to be certain, as we get into court, we state to the judge, before we start this case, I want to go on the record and testify on record to my status before the court. My status before the court is I am a man, I am a woman, I am a living human being. This sounds crazy, but this way they cannot force you to take recognition as a person before the law, and they cannot put you under any other designation. They cannot force you into a statutory court when you do that. They have to stay within the inherent jurisdiction that those courts have.